Welcome to Young Legal Minds. This is stage 2 of answering a misrepresentation problem question, and stage 2 involves identifying an actionable misrepresentation. If you haven't seen my video on stage 1, I'd recommend that you watch it, because without understanding the difference between a term and a representation, you won't understand how to arrive at your conclusion as to whether or not a statement made in a problem question was a misrepresentation or just a term. It's important to understand, because whether a statement was a term or a representation will determine the course of action that the claimant in a case can take. Okay, so it's vital that you understand that in order for a claimant to be able to claim a remedy for a misrepresentation under the doctrine of misrepresentation, then there must be an actionable misrepresentation. There are a lot of pre-contractual statements that will be made which will not incur an actionable misrepresentation, because they won't be misrepresentations. They won't misrepresent some sort of fact. So it's important that you understand that. Now, in order for there to be a actionable misrepresentation, the representor must have made a false statement of fact which induced the other party to enter into the contract. So there are three elements. The false statement, that false statement must be of fact, and that must have induced the other party into the contract. And each one of these three elements must be satisfied, otherwise there cannot be an actionable misrepresentation. So for example, there may be a false statement of fact, but if it doesn't induce the party into the contract, then it won't be sufficient. There won't be an actionable misrepresentation. The same goes for if there's a false statement, but if that false statement is of an opinion and not of a fact. And we'll come on to these three elements now. So the first element is that there must have been a false statement. Now, this false statement can be made through conduct. It does not need to be an oral statement. And that was essentially what happened in the case of Spice Girls. A false statement was made through conduct. Now, in Spice Girls, the Spice Girls, the music group, was required to promote the defendant's products by attending a number of promotional events. However, one of the members of the Spice Girls left during the course of this contract, and this amounted to a false statement through conduct. The reason being was that they had not disclosed that one of the members was going to leave the group, and so in doing so, this member knew they were going to leave prior to the contract being made, and by entering into this contract, they implied that, as a matter of fact, all the group members were going to promote the products of the defendant. When one of them left, this reflected a false statement. There's a quote from the case that says, "The claimant did not know and had no reasonable ground to believe that any of the group had an existing declared intention to leave the group before that date, and that the claimant had done nothing to correct that representation, which was a continuing representation." So you can see how a false statement can be made through conduct. Now, you could say that this was silence, and under the principle of caveat emptor, buyer beware, this should not amount to a false statement. However, it wasn't silence in the strict sense. It wasn't absolute silence, and so it could be a false statement, as was the case in Spice Girls. However, silence in the strict sense will not amount to a statement. This is due to the principle of caveat emptor, which means buyer beware. So buyers should be aware. They should be diligent in assessing contracts and assessing products that they're purchasing, etc., etc. However, there are some exceptions to this general rule on silence. One of them is one that I said was a false statement through conduct, but there is also what's known as a half-truth. So this isn't exactly a lie, and it isn't exactly a truth in the strict sense. It's not a full truth. It's partially true, but not for the right reasons, essentially. And this can be seen in the case of Nottingham Painted Brick, where a solicitor's client asked the solicitor about some restrictions as to some property rights this client had. The solicitor responded with something along the lines of, "I am not aware of any restrictions." That was held to be a half-truth, and the reason being was because, yes, the solicitor was not aware of any restrictions, but the reason being was because the solicitor had not looked into it. The solicitor had not investigated whether or not there were any restrictions in relation to this property. And for that reason, the courts construed this statement as a half-truth. And a half-truth can amount to a false statement, even though it is somewhat true, but on the basis that it's also somewhat false, it amounts to a false statement. Furthermore, if a statement which the representor once made then becomes false due to a change in circumstance, then the representor has an obligation to disclose that change in circumstance. So this is also an exception to the rule on silence. So, for example, in the case of Withen O'Flanagan, the representor owned a medical business, and I think it was £2,000 a month this medical business earned, and at the time that statement was made, it was true. However, there were changing circumstances, and within one particular month, the representor had only made £5, and because he only made £5, there was a change in circumstance. This was the change in circumstance, the dramatic drop in earnings. He failed to disclose that with the representee, who relied on the original statement that it was making £2,000 a month, and that was held to be a false statement. It became false when the representor failed to disclose this change of circumstance to the representee. So this is an exception to the principle of caveat emptor. In some cases, the relationship between the representor and the representee is also something that needs to be taken into account. This is especially true in cases involving insurance companies. So, for example, if Party A is informing Party B is the insurer, as to the risks associated with whatever he is getting insurance on, and he fails to disclose certain information, then that could amount to a false statement, simply because in order for the insurance company to accurately calculate the risk and determine the insurance policy, then the insurance company needs to know of all the relevant necessary risks. So that's the first element of an actionable misrepresentation, a false statement. In the next video, we will be going over a false statement of fact, which is the second element of an actionable misrepresentation.